Good day, everyone. My name is Rowan Haarhoff. I'm the business manager at Munro Forensic Actuaries. Welcome to the latest of our podcast series, which we call Podshots. It's like a shot of espresso that goes straight into your veins, straight into your brains, and allows you to get a little bit more of an understanding of the role of the actuary within mostly the RAF loss space. So today we're going to be talking to Anica van der Westhuizen. She's the third of the actuaries that we've presented within this podcast series. And in this episode, we're going to be looking at recent case law and specifically how the loss has been significantly reduced because expert reports have been found wanting. So welcome, Anica. Won't you just tell our viewers a little bit about yourself and how you came to find yourself in this industry?
Thanks, Rowan. So I have in total 6 years experience in the damages industry. Initially, I started off as an actuarial analyst working in the damages industry straight after my honours degree. I then worked in that for a few years. Then I ventured into the banking industry, worked there for a few years, qualified as an actuary, and then joined Munro Forensic Actuaries.
And you've been with us, I think it's just over 2 years now?
Just over 2 years.
Fantastic. Great. So as I mentioned a bit earlier, today we are talking about recent judgments where the opinions of expert witnesses have come under the spotlight, both in default judgment matters and in trial matters. And the first one we want to talk about today got a lot of media attention, specifically in the Daily Maverick, where we saw the loss of earnings part of the loss got reduced from 9 million to just under R1 million. And that was in the matter of Mole on behalf of MSG versus RAF, which was heard now, the judgment was given now in July. Anica, can you just talk us a little bit through the story in that matter and the eventual outcome in that case?
So in this matter, the claimant was a minor who was 4 years old at the time of the accident. According to the hospital records, he had a swollen head injury. He was fully awake at the time of being admitted to hospital, and he was discharged on the same day. Based on the experts and their postulations, it was postulated that uninjured he would have obtained an honours degree, and injured he's now only able to obtain a diploma.
Okay.
And then based on the industrial psychologist's earnings progression, the actuary calculated a loss of earnings of approximately 9 million rand.
All right. So, Anica, in this judgment, they deal with the legal principle where the judge says before any weight can be given to an expert's opinion, the facts upon which the opinion is based must be found to exist. Can you just talk us through briefly how that legal principle was applied in this matter?
Yes. So the court then said, okay, let's look at the facts in this matter. There was no loss of consciousness at the accident scene. The child's currently performing well at school, and the test even indicated that he has an above-average memory span. The educational psychologist was of the opinion that the child is currently doing satisfactory at school but might struggle with higher grades. However, the court then said there was no factual basis for that and didn't accept the injured. Basically, the court then said the uninjured and injured are equal based on obtaining an honours degree, and the loss should be addressed by contingencies.
And when you say the loss is addressed by contingencies, what do you mean? How does that actually work out?
So a contingency deductions apply to both the uninjured and the injured. In this case, a 5% higher contingency was applied on the injured, which then resulted in a loss.
And when you have a contingency differential applied in these sorts of matters, what is that allowing for? In other words, why is the court, if the uninjured and the injured is the same, why is the court allowing for the differential or asking for the differential?
So the court's allowing for a bit higher contingency deduction on the injured for that differential because they say there is still a probability that the child might not obtain that earnings progression in the injured.
Right, okay. And if I remember correctly, when we were discussing it earlier, you did speak about one of the experts finding that there's some form of post-traumatic stress disorder which could have an impact on the minor's future earnings. Would that be the reason why we have this contingency differential? All right, fantastic. Okay, so that's a really interesting case. Are there other judgments where you've seen similar trends?
Yes. So in Chalelo versus RAF, the claimant was a first-year student at the time of the accident. After the accident, they returned to university but quit after 2 months. never resumed any further studies and remained unemployed to date. The educational psychologist was of the opinion that the claimant won't cope with further studies, and the industrial psychologist concluded that the claimant will remain unemployed in the future. The court found that there was no evidence that the claimant failed any examination when he returned to university, nor that he even tried to find any work. The experts did not consider other forms of education or employment, and the judge was not convinced that the claimant was rendered unemployable, and in the end, this case was also, the loss was also based on contingencies.
On the contingent differential.
Exactly.
All right. And then the case of TPR on behalf of PMM versus RAF, what was the sort of, if you can just sum that up for us in a moment?
So that was a very similar case, also for a minor, also in injured, the experts indicated unemployable, and very similar where the court stated that there was no solid foundation for unemployable, that he still has a residual earnings capacity, and the loss was also addressed by contingencies.
And when you use the term residual earnings capacity, just unpack that for us a bit.
That just means he can still work.
Okay.
So definitely not unemployable.
Definitely not unemployable. Right, fantastic. So far we've dealt with matters where the courts were dealing with the future injured capacity of claimants, and where there was insufficient evidence given to the court to substantiate those reduced earnings. Have we seen similar cases where the uninjured side of the loss has been addressed by the courts?
Yes, so in Lubisi versus RAF, the claimant was a 38-year-old farm worker involved in an accident. And in this particular matter, the industrial psychologist, the earnings postulated by the industrial psychologist, indicated that the earnings would almost doubled within 7 years upon reaching career ceiling at age 45. The judge found that to be improbable, and that the basis for that opinion wasn't explained by the IP, and further indicated that an expert witness should not use speculative reasoning. In the end, the claim for loss of earnings was dismissed.
Okay, so that Lubisi matter was a defendant trial, but there's also the matter of Jale on behalf of NNB versus RAF, which was a default judgment matter. Tell us a little bit about what happened in that case.
So in that case, the minor was 23 months old at the time of the accident. The experts indicated that uninjured he would have obtained a degree, and injured he would qualify as an artisan. The career ceilings they've indicated was uninjured Patterson D1 and injured Patterson C2. The judge indicated that no school reports were provided, and taking into consideration the claimant's young age at the time of the accident, their family dynamics, and their current health status, high contingency should be applied if the actuarial figures are to be accepted. So in the end, the judge then applied a 50% contingency deduction to the uninjured, as well as a 50% contingency deduction to the injured earnings.
So, Anica, the 50% contingency that were applied in this matter seemed to me to be quite high relative to the judges we've discussed earlier. Do you have any reason, or can you give any reason why you think the judge applied such high contingencies?
Yes, so in this case, the judge wasn't explicit in giving reasons to the high contingencies, but we suspect that the judge had doubts about the earnings progressions, and that perhaps the earnings progressions wasn't adequately justified.
And if we had to talk about justifying earnings progressions, do you have some examples that our viewers can identify with when it comes to trying to justify an uninjured capacity?
Yes, so it will all depend on the particular case, but I mean, we can probably look at what's normally looked at for minors and what's normally looked at for employed persons. So for minors, you would typically look at their family dynamics, their educational background and performance prior to the accident. You would also consider statistics about our population obtaining various qualifications, and even how long they take to obtain those qualifications. For someone who's employed at the time of the accident, you would typically consider their educational background, their age, their work experience, their work performance prior to the accident, any growth opportunities they had at their existing employer, but also growth opportunities available within the industry.
So thanks, Anica. Given the the judgments that we've discussed today, is there one takeout or one message that you would like to leave with our viewers?
We see more and more claims being either substantially reduced or dismissed due to expert opinions not being adequately justified. To prevent this, we would encourage attorneys to engage with the experts, to read and understand the reports, to make sure that there is sufficient evidence and that their opinions are justified. Otherwise, they run the risk of claims being scrutinized and possibly reduced or even dismissed.
Thanks, Anica. So what I've also picked up from our discussion today is that the courts are taking far more interest in what the experts are saying, or scrutinizing them. And we're seeing this especially in default judgment matters where you would expect possibly the court just to accept the expert opinion, but they actually are asking telling questions about how the experts are arriving at their conclusions. So as we end today's episode, I'd like to thank Anica for her time being here today and also in preparation for today's podshot. Thank you for listening to today's podshot, and I hope that you found this concentrated shot of information uplifting for you. Please feel free to engage with us on any of the topics that we've spoken about. I actually will be more than happy to take a telephone call, have a consultation with you. If you have any comments, you can please put them in the space provided below or email us at actuary@munrofa.com. We have a rich reservoir of resources on our website where you can get access to previous training or webinars. We have industry templates, and of course you can subscribe to our newsletter. We also have a link to Munro TV in the space below. This is where this podshot, along with the other podshots, occur, as well as other valuable information that we have been producing over the years. Lastly, you will find a link to our Connect portal below. This is an exclusive portal for our clients where they can access their reports, their financial statements, and we're very excited about our contingency calculator that allows our clients to calculate contingencies even with respect to cap matters on all their reports. So thank you for joining us today at this podshot, and we look forward to seeing you next time. Hi, my name is Rowan. I am a trustee of the Kamvalethu Foundation. I'm not sure if you're aware that together with Munro Forensic Actuaries, you as our client are making a contribution to the education of children in under-resourced areas. For every report that you instruct us on, we give a contribution to Kamvalethu, who supports our project partners in these areas. But you can go even further by making a donation. If you go to our website, munrofa.com, and click on the Giving Back tab, you will find more information. Thank you for your support.